who would speak about what the changes are, what to do when a client is being rejected for DSP, the correct processes, and when to appeal decisions. So, okay, Peter, I'd like to welcome you up.
Yeah, g'day, thanks. Thanks for having us. I'll get right into it, and feel free to interrupt if you've got questions or anything. Do I just point it? Okay. I got in trouble, I'm no doubt you guys have already done this, but I got in trouble once from a Chinese interpreter for not doing a welcome to country, despite the fact that there were nobody from Australia in the room, and they all spoke Chinese, and they were all from an obscure part of China, let alone anywhere. I went back and had a look, and they're somewhere next to, where does the Dalai Lama from? Tibet. So they were, yes. Anyway, so I just want to acknowledge that we're on effectively stolen land and of the Wurundjeri people and the Kulin Nation, and I want to acknowledge and pay respects to their elders past and present, and my particular favourite, Auntie Di Kerr, she's fabulous. Anyway, so just done that. I just need to give you some disclaimers to begin with. The first one is about my work. In the sense that what I say I'm responsible for, neither my boss, who will be here for 2 more weeks, nor the boss that will come in January are responsible for what I say, but that kind of makes my life even simpler because one doesn't care and the other one doesn't know. So, so that's the first. The second is, when I'm talking about legislation, I need to explain we don't make it. I can tell you about the law, politicians make the legislation, and if you have an issue with it, they're the people who get paid very large amounts more than I do to do with it. That said, we're very happy to be here. I need to warn you about sarcasm. I might use sarcasm. For those of you who don't know what sarcasm is, it's an attempt at humour using irony. And so if I say something like, I'm really devastated that Tony Abbott's no longer the Prime Minister, you can presume that's sarcasm. If I say something that actually offends you, just presume I was being sarcastic. So if you've got questions, feel free to interrupt, but hopefully I'll get to your point sooner or later. And if I wave my arms around and stuff like that, don't worry too much about that. That's just who I am. And I come from a religious background, and they invented clip art, and I don't believe you should ever have a PowerPoint that doesn't have an image on it. Okay, so, right, getting into it. Just so you know, I'm from Social Security Rights Victoria. We're a community legal centre that works exclusively on social security and family assistance issues, being Centrelink for want of a better concept. We started as the Welfare Rights Unit a long time ago, and we do telephone advice for people across Victoria, except for Geelong, where there's a welfare rights worker at the Barwon Community Legal Service. We're not part of Centrelink, we're not funded by Centrelink. The Welfare Rights Program, which it's morphed into a more general one now, originally took $1 million from what is now Centrelink and gave it to 14 organisations around the country in 1992, and in good years we get cost of living changes. We're about to lose a large chunk of that on the 1st of July next year. We get about 70% of our funding from the federal government and about 20% from the state. Right. Okay, so let's talk about disability support pension and what it is since 2012, okay? So everything changed with the passing of the relevant disallowable instrument, okay? So, which I'll get to. So there are, what we use, a concept of 5 hurdles to get over. You either need 4 or 5 hurdles to be successful. The first is, and I'll go through each of them, but they're basically diagnosed, treated and stabilised, 20 points of impairment, I can look here of course, can't I? Continuing inability to work, aka the 15-hour test, and the 2-year hurdle 4, the 2-year rule. Now in practice, hurdles 3 and 4 are basically one hurdle now. It's continuing inability to work 15-hour test for the next 2 years. And then hurdle 5 is the program of support, which you need which we'll talk about. So you need all 4, the first 4, or effectively all 5, and unfortunately, unlike a whole lot of other things, 3 out of 4 doesn't work. You have to get all of them. I did have a guy who called me the other day and he says, I've got one of them. And I said, which one's that? He says, I've got the program of support. I just don't have the other 4. He said, is it worth me appealing? And we said, well, what else have you got to do on that day? Because it's probably not worth it. I have a picture here, obviously an image of what is known as a lollipop lady in the UK. Obviously there are different genders here in Australia. But if you think about it, that person works for an hour in the morning and an hour in the afternoon, 5 days a week. And if it takes them half an hour to get to work and half an hour to get to home, that's 15 hours per week. If somebody can do that, they probably aren't eligible under the current rules. We'll go, sorry. I've done something, haven't I? Sorry, let me click out of that. Yeah, that's all right. Okay, so hurdle number 1, diagnosed, treated and stabilised. You need to have had all what the hippies call all the allopathic interventions. Okay, so these days, in the old days, you might remember there was a treating doctor's report. That doesn't exist for application purposes now. It's all taken on the medical reports you have, which effectively need to be from treating specialists. Reports from GPs are of value in addition to those. A person also has a job capacity assessment from Centrelink, and sometimes people, where there's some ambiguity, people are sent to a government contracted doctor. Yes, those of you who've been in the industry for a while will think, weren't they around in about 2006? And the answer is yes, they were. Well, they had a slightly different name. They were government medical officers there. Now they're government contracted doctors. Let's just say they're about the same quality. Yeah. Okay. Most people fall over at the first hurdle, to give you a sporting analogy. If they're not considered to be diagnosed, treated and stabilised, they get no impairment points. Now, Centrelink writes a fairly ambiguous letter that says you didn't get 20 points. In most people's cases, it actually should say we have not awarded you any points. So there's a difference between 0 points and nil points. You can be awarded 0 points and have a disability, but it's considered that your disability isn't significant enough. It's not, what's the one below moderate? It's minor. Sorry? Mild, sorry. Thanks, mate. Yes, so, yeah. But that's not what the letters, Centrelink's letters are a challenge at the best of times, but their DSP letter is a particular stinker. And we've been hassling them for years and we've got nowhere, like most of you presumably. So, okay, so hurdle 2 is the 20 points. So this is where the second group of people fall over, for want of a better concept. You need at least 20 points. If you get 20 points under one table, so there are 15 tables I think at the moment, there were more, you're considered to have a severe impairment, and normally you will go on to DSP pretty much straight away. If you have more than 20 points, if you have at least 20 points but not under one table, so somebody may have, say, a back injury and a mental health injury as a result, you might end up with 20 points, but they're under 2 tables, so 10 of each is a common outcome. And you're then assessed whether or not you have actively participated in a program of support. Okay. The continuing inability to work, your condition needs to prevent you from having a functional capacity of 15 hours per week. Okay, so that means that and that's whether or not there's any work that you can actually do or there any work that exists. My favourite line from a letter about DSP was to a young man who lived somewhere north, I think, of Tennant Creek. And now my NT geography is not very good, but it's some distance, I understand, from Alice Springs, some hundreds of kilometres, and he was told he could be a car park attendant. Now, it's safe to say that it was something like a 450 kilometre round trip if he was going to work at a car park, because there was a car park in Alice Springs and there was a car park in Darwin, and there aren't any car parks between. But it had nothing, the whole point is it had nothing to do with reality, someone's actual ability to find work and that work actually existing. They don't use it as much since I made this point at a Centrelink conference, but it used to contain a line that says you could do light clerical work not including heavy lifting. And as I pointed out at the Centrelink conference, that's working for Centrelink. Funnily enough, I've not seen that in too many letters since. Yes. Now, as I said, this now relates pretty much to Hurdle 4. And it's the latest scam, did I say that? The latest thing that appears now is a great trick that Centrelink has come up with by putting things on the never never, by saying to people, oh yeah mate, you've got no work capacity now, we accept that, but in 12 months you might have 8 to 15, and after that, with appropriate interventions, you'll have 15 to 22. Now, nobody knows what those appropriate interventions are. They just make you ineligible for DSP. Yes, so we've asked kind of Centrelink what they consider they are, and they say, oh, you'd have to ask a disability employment service about that. Yes, so anyway, but that's the way they put it on the things. They go, oh, yeah, you clearly can't do anything now, but with appropriate interventions, you could, which we'll come back to because that's kind of what... Again, this is, if people have survived 1 and 2, often this is the one that knocks them out. Effectively, this is already covered now. The condition, effectively the medical reports need to say that the condition's going to last at least 24 months. This is the one that almost nobody loses, apart from my friend who rang the other day who only had the program of support. But again, number 4 is fairly irrelevant now because it's being knocked over, because it's really 3 and 4 are basically the one. Okay. Right. So if somebody has got as far as this, but their 20 points is spread across more than one table, it's then whether they have actively participated in a program of support. Now, just above Len's head there, you can see the relevant bit of legislation, and my eyesight's not all that good these days. Oh yeah, I can read it. The Social Security something and guidelines for the active participation for disability support pension determination 2011. So this came down at the same time as the new tables. The new tables are 63 pages. This is 6 pages, so it's at least quicker to read. Now, the political philosophy behind this is that if you've been given an active, you've effectively, what it actually is 18 months on New Start with an activity requirement. So periods of time where people don't have an activity requirement don't count. Now, what they assess is when you turn up and make your application for DSP, they look back at the past 3 years, so it can be 18 months in a 3-year period that you've done this. But the political philosophy behind it is if people get the proper kind of support, they won't need DSP because they'll have a job. Now, it's safe to say very few of the people who I've spoken to who are in a program of support are actually finding that that's really happening personally for them. It may be happening for somebody else in the organisation, but it's not happening for them. That said, I could just be a cynic, and maybe everybody else it's happening to, but not them. Yes? That's all right. Yes, sir.
Sorry, it's Kathy here. Does volunteering count as work?
It can. It
Oh,
depends.
no.
Sorry?
Oh no.
Yes, the disability. It's technically up to the Disability Employment Service, unless you're with a job active one, which you may be, but in most cases you'll be with a DES. It's whatever they consider. but it can include that. Now, for some people who have a 0 to 8 requirement, often they're not actually required to do much at all apart from come to the occasional meeting, because even the DES has accepted 0 to 8 effectively means nothing. But yes, it can contain that. It contains study and various, whatever the Disability Employment Service, they're brilliantly intelligent and highly educated staff, apologies to any of you if you actually work for a DS, think will assist you to not need to go on DSP. But yes, it can be any sort of thing of that nature. Yeah, okay. Now, the big problem, there are a number of problems with the program of support, apart from the fact that most people don't know they have to do it before they go on DSP. And one of them is that some people turn up at a DES and the DES says, we can't help you because you're clearly too ill and we can't help you get a job because, mate, you're just cactus. Therefore, those people never start their actively participating in a program of support. Yeah, so this knocks people out at the last one. To give you an idea, we were contacted once by a DES who said, I've got this bloke and we can't help him. And he's applying for, and she said, look, I'm willing to come to the tribunal with you and say that. So, we respected this woman. She came to the tribunal and she said to the tribunal member, look, there is nothing our organisation can do for this bloke. He's just not well enough for us to be able to do anything. And the member said, I believe you, but it doesn't matter whether you can help him or not, or the program's of any value. It's just whether he's participated in one or not. Therefore, for want of a better concept to use the thing it's simply a hurdle requirement. Okay. I'm almost done. The other 2012 changes are what we refer to as the morbidity of Table 21. Now, Table 21 was the miscellaneous table in the previous set, and it contained things such as chronic fatigue, and the main one it contained was morbidity. So back in the old days, if you went to see the doctor and the doctor said, Bernie, you're going home to push up roses in the next 6 months, I'll give you a certificate, you go to Centrelink and I'll put you straight on DSP. And that was a good thing for the people who are in that situation. Now, we have had people who are literally 3 weeks away from death and they still aren't eligible for DSP because they don't meet the criteria. So that's the first one. So a lot of the things that people used to get it for, they don't get it for now. The standard amount for chronic fatigue now is 10 points under Table 1. In practice, the tables are much harder. They are functional based. So it's about the way the illness prevents you or affects you doing things, not about the illness itself. It doesn't matter what your illness is. For want of a better concept, that just defines which table you're under, but it's the effect it has of a functional nature. If you qualified under the old table, so this is before 2012, and you're reviewed or go off or something for some reason, and you need to reapply, your chances of success are at best, well, put it this way, I barrack for Richmond in the AFL. And we have much more chance of being the premiers than you do of having DSP. This isn't quite as relevant now. This program's kind of finished. There was the bit about under 35s. Basically, all the people who are on DSP under 35s, apart from the group that went on at 16, most of those have now been reviewed, and a great percentage of them have been removed from DSP. That program effectively finished. You may have heard of the so-called 90,000 that the... he's still the Treasurer, I think. Yes, that's a bit unusual. Talked about in the budget. They're going to review another 30,000 people each year for the next 3 years. Most of those people will be people who went on DSP for mental health issues that haven't been... didn't originally have a diagnosis by a clinical psychologist or a psychiatrist, which is what you need for mental health an assessment by anybody else effectively doesn't count. So under the relevant Table 5, you have to be assessed by a clinical psychologist or a psychiatrist. So they're the next group. Our guesstimate based on what I can tell you is that the number of successful applications for DSP in Australia is in negative territory. So they're kicking off more people than are getting on, and it's down to about 93 or 94%, I think. People need to watch out for what we call the permanent portability scam. And I do have to acknowledge that Centrelink warned people about it, but if someone who's on DSP goes into Centrelink and says, I'd like to go overseas for longer than 4 weeks, they often say to them, well, why don't you apply for permanent portability? And permanent portability means that if you're on DSP, you can go away forever and Centrelink will continue to pay you. So people think, well, wow, that's fantastic, I'll do that. And I'll be able to visit my 15-year-old bride in the Philippines all the time. And anyway, so of course what happens is when you make an application for permanent portability, you make a new application for disability support pension, and the eligibility for permanent portability is that you need 20 points of impairment under one table and no work capacity for the next 5 years. So that's 0 to 8 hours, or 0 to 7 hours technically, I think, for the next 5 years. And most people who get it, again, our unscientific analysis is for every 5 that apply for permanent portability, 1 gets it, 1 keeps their DSP, and 3 people lose it. If you wish to contact us, there are our contact details. I'm happy to provide those to anyone who needs it. And with that, unless people have questions they want now, I'll hand over to Len.
And I too would like to pay my respects to the traditional owners of the land, past and present. I've got a PowerPoint that was really designed for another purpose, but there's a few slides that might be useful, which I may get to, or I may not, because sometimes I get distracted and lost. Perhaps if I first explain who I am. My name's Len Jaffit. I manage what we call our Commonwealth Entitlements Program at Victoria Legal Aid, and we cover 3 main areas of work. We cover Centrelink disputes, we cover some limited work in the NDIS space, and we deal with people who are charged with Centrelink offences, obtaining money, knowing or believing they're not entitled to that money. Excuse me. We provide services at what I call 3 levels of intensity. We provide advice over the telephone for anybody with a legal question around Centrelink. In appropriate cases, we'll provide a face-to-face appointment to look at documents, provide more detailed advice, and in some cases we can formally act for people on an ongoing basis. Most of the formal work we do is at the tribunals, and I'll explain what all of that means in a second. Just before I forget though, there's a couple of things out of Peter's speech that I just want to mention. Peter is absolutely right. The program of support is a huge issue and a huge difficulty for many people applying for disability pension. There is one circumstance where people don't have to have done 18 months out of the previous 3 years, and that's if they meet one of the exemption criteria. However, there's kind of a catch-22 for that, because you have to have actually been enrolled in the program of support prior to claiming the pension. As Peter pointed out, most people don't even know what a program of support is, and most people with disabilities get a medical certificate exempting them from the activity test for New Start, which really stops them starting the program of support. So they're in the situation where basically they never get through the gate. If they can get through the gate, if they can actually commence with a disability provider before they claim pension, and the disability provider forms the view that because of their permanent disabilities, the program won't assist them or they can't do the program, then they can be exempt. But there's really a catch-22 situation arising from that. In terms of how I explain how to deal with Centrelink to pretty much everybody that rings who's not happy with Centrelink. I have a kind of framework that I deal with it. In essence, when people are not happy with Centrelink, it really boils down to one of three reasons. Either they've been charged with an offence, and we're not talking about that today, so forget about that. Or they're not happy with a decision Centrelink has made under the Social Security law. Might be a decision to reject pension, to raise an overpayment, to cancel a payment, to reject a claim for New Start, to pay them at a particular rate. All of those things are decisions under the Social Security law. Anytime a person disagrees with that, they have a statutory right of review and appeal. They firstly have a right to have it formally reviewed internally by an authorised review officer. That's a senior Centrelink officer that has not looked at the matter previously, who will do one of two things. They'll either agree with the person and change the decision in their favour, or they'll write a detailed letter explaining why they've made whatever decision they've made. From there, if the person is not satisfied with that decision, they can appeal to the external tribunal, the Administrative Appeals Tribunal. And the first tier of that, or the first level, used to be called the Social Security Appeals Tribunal. You can lodge an appeal by telephone. It's really a simple matter. Despite the fact that Centrelink is, the legal term is a nightmare, and the Social Security law is unbelievably complicated, the actual review and appeal system is really quite simple and user-friendly if you can get through on the telephone. You don't have to do it by phone, you can do it in writing, but you can lodge an appeal, request for review by phone. You can lodge an appeal to the first tier of the AAT by phone. From there, from the first tier of the AAT, if either you or the department think that decision is wrong, there is a next level of appeal at the Administrative Appeals Tribunal, which is slightly more formal, and Centrelink's legal team are actively involved in that. So that's the review and appeal system. Now, the other circumstance where people are not happy is what I loosely call service issues. They're not happy because Centrelink lost a claim form, or they refuse to process something, or they've given bad advice, or you can't get through on the telephone. All of those things are what I call service issues. You can't take them through the review and appeal system, but you can make a formal complaint to Centrelink, and if you're not satisfied with that, you raise it with the Commonwealth Ombudsman's Office. The more times people appeal about these things, the quicker things are done. So, for example, if it's a matter of just simply being unable to get through on the phone, you might want to take that up with the Ombudsman, or you might want to go into your local Member of Parliament. Because the other point Peter made is equally valid. We don't make the laws. Centrelink don't make the laws. Members of Parliament make the laws. And they also resource organisations like Centrelink. Now, if I can find the right slide. That's a photo that has nothing at all to do with Centrelink, but that was my first grandchild. He's much older now. The reason I put that in is one of my colleagues thought that was to demonstrate how simple it was to seek a review or appeal, whereas actually it was just because I was a doting grandfather. But importantly, the reasons for seeking review and appeal are that it can have a huge impact on people's lives. And most people are unaware of this. This is data from 14-15, and it's been reasonably consistent for 10 to 20 years. About a third of people that seek an internal review by an authorised review officer have the decision changed. Not always 100% in their favour, but that's 3 out of 10 times or more that Centrelink get it wrong at first instance when people query it. From there, people that take it to the next level, SSAT is now the first tier of the AAT, about 25% have the decision changed. From there, people that take that on to the second tier, about somewhere between 20 and 30%. I think that bottom figure is actually wrong. I think it's higher than 20. Or perhaps for a couple of years either side, I think it was 25%. The other interesting thing is that of the reviews and appeals at the second tier of the AAT, about 60% of those nowadays are about disability support pension. When I first started working in this area, which was many decades ago, For a long period of time, about 30% of the appeals were disability pension, the rest were about non-medical issues. I don't have any evidence for this, but that's never stopped me from doing anything in my life. I think the reason why there are more appeals about a disability pension percentage-wise is twofold. One is, progressively over the years, it's become more and more difficult to meet the medical requirements to get disability pension. The other thing is that many years ago, the way pensions and New Start were indexed changed. Disability pension, like age pension, is linked to the all-male average weekly earnings. New Start was linked to cost of living. What that's meant is, even though at one time the single rates were identical, over time they've drifted further and further apart. New Start now is less than 2/3 of the rate of disability pension. So there's an increased incentive for people to be on the pension. So that's why I think the percentages have gone up. That's also why I think the set-aside rate at the tribunals has gone down, because I did the similar exercise about 5 years ago, and for a long period of time, the set-aside rate at the SSAT was around 30-35%. So the way I kind of explain that to lay people is, if you're dealing with Centrelink and they make a decision and you feel it's wrong, there's a 30+% chance it is wrong. So there's usually very few risks in seeking review or appeal. If it's about an overpayment, you need to be aware that overpayments can increase as well as decrease on appeal. But if it's about a rejection of something like disability support pension, you can't be worse off. They can't affirm the rejection and also say, well, you can't reclaim for 20 years. So there's often every reason to seek review or appeal. The other thing I was going to say quickly before I get lost in this, there's some contact details from my team. All of these are available on the internet. We have Legal Aid has an internet page. There's some information specifically about disability pension that we put up quite recently. I would encourage people to look at those resources, as well as those similar resources on Social Security Rights Victoria's webpage, and New South Wales Legal Aid also has some useful information about disability pension. If you are assisting somebody who's claiming the pension or assisting them through the review process, it's important to realise that really these things turn on the medical evidence. So it's important to get reports from their treating doctors, from specialists, indicating what the diagnosis is, what the functional impact of their conditions are, and what treatment they've had. That's necessary to address the things, the requirements of fully diagnosed, treated and stabilised. As Peter pointed out, these days to get any points at all for a mental health condition, there's a threshold requirement. You need a diagnosis from either a clinical psychologist or a psychiatrist, but you only need the diagnosis from them. You can evidence from other practitioners, like psychologists that are not clinical psychologists, or GPs who are assisting you with your medication, that can be used to allocate points, provided you've got over that threshold diagnostic question of a diagnosis from a clinical psychologist or psychiatrist. Importantly, that diagnosis can actually occur after the date of claim. There's a decision of the General Division of the Administrative Appeals Tribunal, the second tier. If anybody feels like reading things like this, it's incredibly important. It's in the name of EID. It's by a senior member that's very well respected. It's got some very useful information, and we use it in arguments at the AAT day in, day out. Sorry, I got a little bit sidetracked, but there's one more slide that is incredibly important. There it is, that's my granddaughter. That one's kind of contemporaneous. She isn't much older than that. Gulliver and the other one is now 6, but It's too cute a photo to throw away. The last thing I'd say is that the other thing that we provide in my team at Legal Aid is if any workers have questions about Centrelink matters, they can also ring through for advice. Because I'm so conscious of the fact that there's very few of us, including people at Social Security Rights Victoria that actually have expertise in this area, and also conscious of the high set-aside rates on review and appeal, I just encourage everybody to be aware of the review and appeal system, to assist clients to lodge those review and appeals if that's what they want to do and you think it's wise. And if matters get complex, you can always call on people like us or SSRV for further advice. Thank you, and now Peter and I would be more than happy to try and answer lots of questions.
NDIS rejection and appeal system, and my question is if any of your organizations deals with specific appeal, NDIS appeal system?
So I'm not quite sure I understood. Was the question about the appeals process for NDIS? Yeah. Okay. I have a little bit of knowledge, but not a lot of knowledge in that area. I've been working in the Centrelink space for 30 plus years. NDIS is far more recent. Having said that, Legal Aid does do some work at the general division of the AAT. There is a not dissimilar review and appeal system. And again, there are some complications that I think are completely unnecessary. In the NDIS, they talk about, they use the word review in two contexts. They use it in the context of a plan review, that's a review of somebody's NDIS plan, and they also use it in the context of a reviewable decision. So if the NDIS make a reviewable decision, which might be a decision to refuse access to the scheme, it might be a decision to fund a particular level of supports where the person wants different or more supports, they would be reviewable decisions, and a person has a right to have that internally reviewed, so not dissimilar to the authorised review officer process. From there, they can take that decision to the Administrative Appeals Tribunal. The difference is there's only one level of external review, which is comparable to the second tier for a Centrelink matter. So there's not an equivalent of what used to be the Social Security Appeals Tribunal. The reason that's kind of important is for the first tier of the AAT for Centrelink decisions, for what used to be called the Social Security Appeals Tribunal, that's an appeal where Centrelink are not actually involved in the appeal. The person lodges the dispute lodges an appeal saying, I disagree with the decision to reject my disability pension claim or to cancel my disability pension. The tribunal notifies Centrelink, and Centrelink provide the file papers, and that's really the end of their involvement at the moment. The tribunal then provides a copy of the papers to the person and arrange for a hearing time where the person can say to a tribunal, which is usually one or two members, why they think the decision is wrong, and the tribunal will then make a decision and usually send it to the person within a fortnight. So Centrelink's not actually actively involved. At the next tier, the general division of the AAT, Centrelink are actively involved. So there's pluses and minuses to that. The plus is it gives an opportunity for the person and Centrelink to actually reach an agreement without the need for a hearing. So often at the general division of the AAT, we will we'll act for a person and we'll provide additional medical evidence and we'll convince Centrelink's representative that the person is qualified for the pension and they'll agree to grant the pension without the need for a hearing. So that's the plus. The minus is it's much more formal. If it goes to a hearing, Centrelink's lawyers are there, they cross-examine the person and their witnesses on their evidence. It's a formally recorded, actually forget I said that because the lower tier is now recorded. But it is a much more formal process, much closer to a court of law than an informal tribunal. Excuse me. So the NDIS appeals are at that general division and they are very formal. Even though the AAT has gone out of its way to try and make user-friendly processes, have case managers allocated to the appeal, it's still pretty formal and pretty adversarial. and occasionally exceedingly frustrating. Sorry, I hope that answered your question. I got a bit sidetracked, as is my wont. I'm a lawyer, what can I say?
Any other questions?
Hi, it's Winnie Bridie from Children and Young People with Disability Australia. In the recent audit of the qualification process for the DSP that there's currently a parliamentary inquiry about, one of the findings was around that the appeals process, or given the increased number of people who are making appeals and having claims rejected, is actually increasing, costs associated with administrating the DSP. And then the auditors made a recommendation that, or made a finding that this could be partly sort of addressed by providing better information to people about why their claims have been rejected, and also just noting that the audit didn't involve any direct consultation with DSP claimants or recipients. Do either of you have any views about that finding and whether it has merit, I suppose? And DSS and DHS haven't said how they will respond to it, but they've accepted that recommendation, I suppose?
Sure. Funny you should mention that. There was a very short time frame for putting in submissions to that inquiry. Legal Aid put in quite a detailed submission with not too many typos, and we're going up on Wednesday to give evidence to the inquiry, and that is one of the things that we absolutely agree with. It's not just the lack of information around the reasons for rejection, it's a lack of information about things like a program of support. So often people have lodged a claim, and it's only when they get to the tribunals that they even understand vaguely what a program of support might be, and by that stage they've lost a year or two of possible entitlements. So there are huge problems with the way it's administered. I think there's huge problems with the way the program of support directive is made. Obviously there's an acknowledgement that some people are not going to benefit from a program of support, and that's kind of written into the direction, but the way it's worded, in that you actually have to have got through the doors of a program of support before you lodge your claim, kind of results in a catch-22 for a huge percentage of clients. And often the first time they're aware of that is when they talk to us or people like Peter. So yeah, the short answer is I completely agree. There's a number of points we made, including around the new medical processes. The way the Commonwealth medical officers used to work is that, because unfortunately I remember a time in the early 70s, the Commonwealth medical officer pretty much used to make the decision as to whether somebody was medically qualified for what was invalid pension back then. They would tick a box, either PI or not PI. If they happened to tick the wrong box by accident, they would rarely change their minds. I only know that because I saw one where it was crystal clear that's what had happened, because the box tick just did not match the rest of the form, and the guy was terminally ill, and the CMO just refused to accept that he'd done that. But I digress. Then it became apparent that legally the decision belonged to a social security officer, not to the doctor, and the pendulum shifted. Now we have a situation where they've kind of reinvigorated the Commonwealth medical officers. My understanding is they use them, if an authorised review officer wants to agree that the disability pension claim should be rejected, that's fine, they just go along and reject it and they don't talk to the Commonwealth doctors. But if they want to change that decision because they think the original decision was wrong, they need the Commonwealth medical doctors to review that decision. So it's kind of just a further barrier for people in reality. So as I said, we think there's a range of procedural problems that were highlighted by that audit report, and it will be interesting to see what the department's response ultimately is.
I think just to add to that, there's been a fallacy around, well, they talk about it in the Old Testament to give you an idea, about that if you just explain something to people, they'll say, oh, okay, I must be wrong. Whereas we don't really subscribe to that. We understand that the further people go in the process, the more they seem, the more they understand. But the long and the short of it is, it goes back to what Len says. New Start is 2/3 of DSP, and these people are ill. Why aren't they eligible for DSP? And no amount of kind of things, and there's some good stuff. The AAT has just printed some very good stuff about DSP in the last week as well on their website. But little of that changes what's really the economic and health issues that are pushing people towards DSP. And this is the outcome of the government changing the rules. It changed the rules. It pushed a whole lot of people off DSP. Those people have a right to appeal. It's just, if it's economically taxing for the government, I'll try and not cry too much about it.
Hi, Kathy Barakas here. Peter, can I just ask you a question about the support programs? The Centrelink is a federal organisation.
Yes.
What if the person is volunteering under a Victorian state government provider or support program? Or are they the same thing under the definition of support?
It's all about whether or not it's an approved activity. So that is, the approved activity is approved by the Disability Employment Service. So they might say, what are you doing? Oh, I'm volunteering at Vinnie's. And they go, oh yeah, that's all right. We'll put that in.
But this individual is not with with a DES provider. She's under a transition to work provider. So she's 20 years old, let's say. So she's on the disability support pension.
She's already on it?
She's already on it.
The program of support, don't confuse the program of support with the activity requirement that some DSP recipients have. So some DSP recipients, particularly those under the age of 35, have an activity requirement, but it's not a program of support.
Okay.
The program, they may be the same, for want of a better concept, in what actually occurs, but the program of support is specifically for somebody who usually is on New Start. Okay. So again, but it's not dissimilar. It still needs to be approved by the Disability Employment Service. And they can approve just about anything, for want of a better concept, and there's no reason that it can't be, but there's no reason that it automatically will. Okay, so.
Thank you.
Does anybody else have a question before we wrap up?
It's just a question. So we just have a client. We're an advocacy service for people with disabilities. So we do lately have a high number of people accessing our service with regard to the disability rejections of the application. So just recently, a person was Centrelink was given 10 points for the person's back problems. And this person has several health issues, has seizures, and that was not, Centrelink didn't give any points for her, seizures. She has, internal hernias that she requires to undergo a major operation. And with the treatments, she's not allowed to lift any heavy things or she can't even drive. But Centrelink seems to, say that she's not qualified for the DSP. They required her to do some activity program, and they even recommended an employment service for these persons to attend to. But at the end of the letter, they even advised her not to start any, activity till February. With that saying that, now the person's got some hope. They say, what do they mean? They mean that, I've still got the chance of opportunity that they will revisit my, case? And I couldn't answer that. So why could you?
Okay.
Sorry, just before I forget, there's no way there's no way I can answer that either because I don't have enough information. But generally speaking, if a person lodges a claim, Centrelink should make a decision. If the person doesn't like the decision, they go through the review and appeal system.
That's right.
But the one thing I forgot to mention is that a person has a right to lodge as many claims as they like. So we often see people who are appealing a decision made, say, a year ago, that's finally got through to the tribunal. And that's a decision about whether they were medically qualified at the date of that claim a year ago,
Yeah.
whether their conditions were fully diagnosed, treated and stabilised back then. And almost invariably I will advise people that they may also want to lodge another claim now to test their entitlement today and see whether their conditions are fully diagnosed, treated and stabilised today.
I see, yeah.
If it's refused, they can go through a review and appeal about that. If it's successful, they're on the pension into the future and they can still continue with their appeal, and that just then becomes about whether or not they get back pay.
Oh,
Do you understand what I'm
yeah,
getting at?
Yeah, I do. Yeah.
So just
yeah.
to conceptualise it, try and think of it, if a decision's been made and I don't
Yeah.
like it, I can go through the review and appeal
Yeah,
system.
yeah,
Sorry,
yeah.
Peter, I just forgot about that.
The only thing, again, in agreement with Len, we can only give you rough ideas. The two things I will say is that if somebody has an operation they need to have, they can't be considered to be diagnosed, treated and stabilised until they've at least had that operation, because under the pure theory, they might have that operation and then they'll be better, you see?
Yeah.
Right? So that's the first one. The second one is the exemption is an exemption that they've got until February, is an exemption from New Start, which Centrelink effectively says, we know you can't do anything now. Right? So that's why, but if they, that period, for example, doesn't count towards a program of support because they've got an exemption. Okay, now they don't have to do anything and they'll be paid New Start, that's all good, but if they're hoping to stack up some program of support credits, for want of a better concept, the period that they don't have an activity requirement for doesn't count.
So the longer, that the person is waiting to start that activity program, it's not helpful to the person's case.
If that's one of the reasons they're not
Yes,
going to be
yeah.
successful, yes.
Yeah, thank you.